A businessman crosses the Oshoek border into Eswatini on foot. No return recorded. Months later, he messages his lawyer from a hidden phone asking if it's safe to come out of hiding. Now prosecutors race against September 17th to convince a judge that if Vusimuzi cat Matlala gets bail, he'll vanish forever. Matlala sits in custody at Alexandra Magistrates Court this September 2025, facing charges that could destroy everything he's built. Attempted murder of his ex-girlfriend, actress Tebogo Thobejane, conspiracy to commit murder, money laundering. The state calls him a dangerous individual with every reason and resource to flee. His company, CAT Protection Services, continues operating while he fights for freedom, but prosecutors paint a darker picture. They see a man who's already proven he can disappear. The evidence seems overwhelming at first glance. 600 pages of WhatsApp messages recovered from seized phones, a fake Eswatini identity document bearing the name Dlamini, border crossing records showing suspicious patterns. But Matlala's defense team, led by advocate Lawrence Hodes SC, attacks each piece systematically. They claim police tampered with the phones during the December raid. They say the messages were planted. They insist their client is a legitimate businessman being persecuted without hard evidence linking him to any shooting. Now, the state argues both flight risk and danger to society. They point to evidence of secrecy and foreign ties, claiming he might abscond if released. The prosecution mentions alleged offshore assets, including a Mauritius trust that Matlala only recently acknowledged. They describe cross-border movements that suggest someone preparing escape routes. Meanwhile, Matlala's lawyers counter that he has strong family and business ties keeping him in South Africa. They emphasize he has no past violent convictions. They argue the charges are baseless and unsupported by forensic evidence. The judge must weigh these competing narratives before September 17th. One side sees a dangerous fugitive in waiting. The other sees an innocent man trapped by circumstantial evidence and prosecutorial overreach. The violence erupted on the N1 highway near Sandton in October 2023. Tebogo Thobejane was driving when shooters ambushed her vehicle. The bullet struck her foot, leaving lasting trauma she still carries. But she wasn't the only victim. A female passenger in the car suffered catastrophic spinal injury. She remains paralyzed, her life forever altered by those moments of gunfire. Yet Matlala wasn't arrested then. According to his sworn affidavit, he learned about the shooting from media reports like everyone else. He claims Thobejane contacted him repeatedly after the attack, seeking help and protection. This version of events suggests a concerned ex-partner, not a would-be killer. But prosecutors see it differently. They argue this was a premeditated assassination attempt, carefully planned and ruthlessly executed. The relationship between Matlala and Thobejane had ended in September 2021, after about 13 months of dating. No reported acrimony marked their split at that time. 2 years passed before the shooting. This gap raises questions about motive that both sides exploit. The prosecution suggests long simmering resentment or fear of exposure. The defense argues the time delay makes Matlala an illogical suspect. Thobejane hasn't testified in open court, but her written statements speak volumes. She fled South Africa after the shooting, communicating to investigators that she feels exposed, unsafe, and unprotected. In messages relayed by the investigating officer, she expressed fear for her life. She's also made allegations about Matlala's past misconduct, though these remain unproven claims rather than established facts. The shooting itself is indisputable. Real bullets, real blood, real paralysis. But connecting Matlala to the trigger requires a chain of inference the defense attacks relentlessly. Home Affairs Section 212 records tell a peculiar story. On February 11, 2024, Matlala crossed the Oshoek border into Eswatini on foot. He returned to South Africa on February 12th. Then on April 19th, he crossed again into Eswatini, this time with no return entry recorded in the system. The prosecution emphasizes these odd patterns. Why would a wealthy businessman with alleged access to private jets walk across borders? Why stay only one night before returning? The state suggests these movements indicate someone testing escape routes, establishing patterns that could later facilitate permanent flight. They question why Matlala would repeatedly cross back and forth if not laying groundwork for eventual disappearance. But there's a problem with the state's narrative. Matlala hasn't provided return trip records or a valid passport to support these border claims. The defense offers no clear explanation for these crossings. This silence becomes its own form of evidence, suggesting either calculated evasion or simple inability to explain seemingly suspicious behavior. The Oshoek-Ngwenya crossing point sits close enough to Johannesburg for quick trips yet far enough to complicate surveillance. It's a route someone might choose if they wanted options. Someone who needed to know they could leave quickly if circumstances demanded. The prosecution argues these crossings reveal consciousness of guilt, preparation for the moment when staying in South Africa became impossible. Now consider the timing. The December 2024 police raid happened months after these border crossings began. By then, according to prosecutors, Matlala had already established his escape infrastructure. The groundwork was laid before anyone came looking. March 18, 2025. A WhatsApp exchange that prosecutors call the smoking gun. Matlala messages his wife Tsakani, "Please send me the identity document because I deleted it." She responds with a photograph of an Eswatini ID card. The name on the document isn't Vusimuzi Matlala, it's Dlamini. This alias appears elsewhere in the evidence. On Tsakani's phone, Matlala's number is saved as Hubby, but in communications with his lawyer, the same number appears under Dlamini. The prosecution connects these dots into a picture of deliberate deception. Here's a man with a fake identity, using it to communicate with his legal counsel about hiding from authorities. Then comes the December 22, 2024 message that prosecutors repeatedly cite. Using the Dlamini identity, Matlala asks his lawyer, "Can I come out of hiding?" He follows with another question, "Can he go home to Eswatini as I am still in hiding?" These aren't the words of an innocent man, prosecutors argue. They're the communications of someone actively evading justice. But Matlala denies everything about this identity. He claims he never knew about the ID or its photo. He insists he never used the Dlamini alias. His defense team suggests the evidence could have been fabricated, planted on phones that police controlled for days after the December raid. The state finds this denial implausible. They argue the extensive chat histories, with matching content and timestamps across multiple devices, couldn't have been faked. The sheer volume of data, 289 pages from Tsakani's phone and 386 from Matlala's, suggests authenticity. Manufacturing such detailed, synchronized communications would require sophisticated planning and technical expertise. Yet the defense maintains its position. They received the phones back too late to properly analyze them. They claim tampering is not just possible but likely given the stakes involved. Money changes everything in a bail hearing. A defendant with resources poses different risks than one without. The prosecution claims Matlala holds undisclosed foreign assets that could facilitate permanent disappearance. They cite an affidavit noting he only recently admitted to a Mauritius trust account interest, suggesting a pattern of financial non-disclosure. The allegations go further. Prosecutors claim he owns a private jet and luxury boat based in Mauritius. These are the assets of someone who could vanish at will, they argue. Someone who could slip away from South African justice and establish a comfortable life elsewhere. But Matlala vehemently denies these claims. No concrete records have been provided. No registration numbers, no purchase contracts, nothing beyond assertion. The Mauritius Trust is different. Matlala acknowledges it exists, though he disputes any obligation to declare what he claims he doesn't fully own. This admission becomes a double-edged sword. It confirms he has international financial connections while raising questions about what else might be hidden. Now consider Matlala's known wealth in context. He's described as a controversial businessman and tenderpreneur who secured multi-million rand government contracts. Media reports have tied him to corruption probes, including a 360 million rand South African police service tender and allegations involving Tembisa hospital contracts. While he hasn't been formally charged in those cases, the associations paint a picture of someone with access to significant, potentially illicit funds. The defense argues these unproven allegations prejudice the bail hearing. They insist Matlala's business success, however controversial, doesn't make him a flight risk. They point to his established company, his family ties, his roots in South Africa. Why would he abandon everything based on charges he claims are fabricated? But prosecutors see it differently. They see a man with means, motive, and demonstrated ability to obtain false identities and cross borders undetected. The wealth isn't just about comfort, it's about capability, the capability to disappear. December 6, 2024. SAPS raids. Matlala's home without a warrant, citing intelligence about a kidnapped person potentially held there. Major General Mbuso Khumalo later files an affidavit justifying this Section 22 operation. Officers seize 5 firearms and 5 mobile phones, 3 iPhones and 2 Nokias. No laptop or tablet devices are taken, countering some rumors about the raid's scope. The phones are returned on December 12th. But according to Matlala, something happens during those 6 days. He later admits to destroying his and his wife's original phones after getting them back, keeping only the returned devices. This destruction becomes crucial because when police arrest him on May 14, 2025, they seize 2 new phones. And these phones contain the WhatsApp evidence that forms the prosecution's case. The timeline matters enormously. Police had physical control of the phones for 6 days. The defense argues this was enough time to plant messages, create false conversations, manufacture evidence. They note Matlala only received the phones back on the morning of his bail proceedings, leaving insufficient time for proper forensic analysis. The prosecution counters with the sheer scope of the evidence. Those 600-plus pages of chats show consistent patterns across multiple devices. Messages sync perfectly between phones. Timestamps align. Conversations flow naturally over months. The state argues it would be implausible for police to fabricate such extensive, detailed communications. Now the technical battle begins. Can deleted WhatsApp messages be recovered? Yes, both sides agree. Can messages be planted on a phone? Technically possible, the defense argues, but could hundreds of pages be created with perfect synchronization across devices? The prosecution says no. The defense says they weren't given the chance to prove otherwise. This isn't just about technology, it's about trust in the justice system. If the phones were compromised, the entire case collapses. If they weren't, Matlala's own words condemn him. The judge must decide which narrative to believe without absolute technical certainty. September 17, 2025 approaches. Magistrate Dita Prinsloo must make a decision that could determine whether justice is served or subverted. The bail application has revealed a case built entirely on circumstantial evidence. No forensic ballistics link Matlala's seized firearms to the shooting. No witnesses place him at the scene. No direct evidence connects him to the gunman. Instead, the state presents a web of suspicious behavior: the fake identity, the border crossings, the hiding messages, the undisclosed assets. Each piece alone might be explained away. Together, prosecutors argue, they reveal someone preparing for and executing a planned assassination attempt, then positioning himself to escape consequences. The defense sees persecution without proof. They highlight the gap between suspicion and evidence. They emphasize that Matlala cooperated with searches, submitted to arrest, engaged legal counsel. These aren't the actions of someone planning to flee, they argue. They're the responses of an innocent man trusting the justice system. But Thobejane's fear hangs over everything. She's fled the country. She says she's in danger. Her passenger remains paralyzed. These realities demand the court consider public safety alongside presumption of innocence. Can the court risk releasing someone the victim herself fears? Or would denial of bail based on unproven allegations set a dangerous precedent? The prosecution makes their final argument. They've shown means through Matlala's wealth. They've shown opportunity through the false identity and border crossings. They've shown consciousness of guilt through the hiding messages. They argue that releasing Matlala risks both public safety and justice itself. He could disappear into Eswatini or beyond, leaving victims without recourse and the state without a defendant. The defense counters with fundamental principles. Bail is a constitutional right. Pretrial detention should be exceptional. The evidence against Matlala is circumstantial, contested, and potentially compromised. They argue that denying bail based on such evidence would violate the presumption of innocence that protects all citizens. As September 17th arrives, larger questions loom beyond this single case. In an era of digital evidence and sophisticated legal challenges, what constitutes proof? When wealthy defendants can afford top legal teams and potentially escape across borders, how does the justice system ensure accountability? If police can seize phones and later produce incriminating messages, what safeguards protect the innocent? The Matlala case isn't just about one man's freedom or one woman's safety. It's about whether South Africa's courts can navigate the intersection of technology, wealth, and justice. It's about whether circumstantial evidence and suspicious behavior are enough to keep someone locked up before trial. It's about trust, not just in individuals, but in institutions. The businessman who crossed into Eswatini with no return, recorded, now sits in custody, his fate resting on a judge's interpretation of ambiguous evidence. The woman who fled South Africa in fear watches from afar. The paralyzed passenger lives with permanent consequences, and the justice system itself stands trial, its ability to protect victims while preserving rights under scrutiny. Come September 17th, Magistrate Prinsloo will render judgment, but regardless of the decision, questions will remain. Did Vusimuzi cat Matlala orchestrate an assassination attempt, or is he the victim of an elaborate prosecution built on planted evidence? Can someone truly vanish in today's interconnected world, or do digital footprints make escape impossible? When technology can both reveal and potentially fabricate truth, how can courts determine what really happened? These aren't just legal questions, they're questions about power, truth, and justice in modern South Africa. And as the bail decision approaches, they remain frustratingly, dangerously unanswered.